Well, I'm very happy to be here tonight. I know Bob Gorman was really looking forward to presenting to everyone. So really, if you would keep him in your thoughts during this time, he would appreciate that. Again, thank you so much for having me. This is a very important topic to be familiar with. I know it's a serious topic, but I hope I can be informative for you. Can everybody hear in the back? Yes? Okay. Just checking. So today I'm going to discuss what your legal role is in responding to instances of child sex abuse and neglect when you do encounter them in your profession. Admittedly, your legal role is extremely complicated, especially here in Ohio. The state laws differ from state to state very widely, and Ohio has one of the more complicated laws of the bunch throughout the United States. Okay, so we want to differentiate between your pastoral role and your legal role. As pastors, you're men and women of God, and you've had spiritual training. With experience, you know how to deal with confessions when they come to you in your pastoral role, but your legal obligations are not always intuitive, and in fact, sometimes they can be pretty counterintuitive. I want to address the different legal obligations for clerics in Ohio and how those obligations differ from others, quote unquote, rendering spiritual treatment through prayer as it relates to reporting child abuse. Before we get started, I wanted to give you just a quick reminder that this presentation is an overview focused on Ohio law. I know many of you come from different states, and as I mentioned earlier, the reporting obligations vary widely from state to state. This is just a summary of the law. The law is very complicated, and we could spend an entire day going through all the intricacies of what the law requires. So this is not intended to be specific legal advice applied to a specific fact pattern. And consider consulting with an attorney of your choice in your particular state if you do have a legal question that arises during the course of you performing your duties either as a pastor or as somebody else in the church. So in order to know when you're legally required to report instances of abuse and neglect, you first need to know what the definition of abuse and neglect is under the law. So neglected child, what's printed on this slide here comes from the Ohio statutes. Neglected child includes any child who's abandoned, who lacks adequate parental care, whose parents neglect the child or refuse to provide the proper subsistence, education, medical or surgical care or treatment to the child. So that's very broad. Neglected child, you can encounter that in a lot of different scenarios. Neglected child also includes a child whose parents neglect the child or refuse to provide the special care made necessary by the child's mental condition. It also includes a child whose parents have placed or attempted to place the child in custody of an institution or foster home without following the proper legal protocol. Also includes a child who, because of the omission of the child's parents, suffers physical or mental injury that harms or threatens to harm the child's health or welfare, or also a child who is subjected to out-of-home care, child neglect. And in this definition, when it mentions the child's parents, it also applies to a child's guardian or any other individual who is in custody of the child. And if anybody has any questions as I go through along through this presentation, feel free to just interrupt and I'd be happy to answer any questions. And we went over the definition of neglect. The definition of abuse is also found in Ohio's law. An abused child includes any child who is the victim of sexual activity. What is printed here on this slide is how Ohio law defines sexual activity. And as you read it, it's very broad. It includes a lot of different acts. So if you encounter a child who may have been the victim of sex abuse, it's probably wise to err on the side of thinking, yes, maybe this does fall under the definition of sexual activity. In addition to a child who's subjected to sexual activity, abused child also includes a child who is endangered, who exhibits evidence of any physical or mental injury or death inflicted other than by accidental means, or injury or death which is at variance with the history given of it. A child exhibiting evidence of corporal punishment or other disciplinary measure by a parent, guardian, or other person having custody or control of a child is not child abuse. So if somebody is spanking their child without unnecessary force or inflicting unnecessary harm on the child just during the course of parenting that child, that does not fall under the definition of child abuse. Abused child also includes a child who, because of his parents, suffers physical or mental injury that harms or threatens to harm the child's health or welfare, and also a child who is subjected to out-of-home child care abuse. So we've seen that child abuse can include both mental and physical harm, and include both harm that was committed against a child or is threatened to be committed against a child. And the perpetrator of that abuse can be the child's parents, guardian, or other custodian. So under the law, certain people are required to report instances of both known and suspected child abuse and neglect. We refer to these people as mandatory reporters, and the list of mandatory reporters is found in Ohio law, and the mandatory reporters include attorneys, medical professionals, licensed school psychologists, marriage and family therapists, coroners, employees of a child daycare center, employees of a child day camp, school teachers, school employees, and pertinently, persons other than a cleric rendering spiritual treatment through prayer in accordance with the tenets of a well-recognized religion. And the individuals I have listed on this slide are just some categories of the mandatory reporters in Ohio law. There are other categories listed in Ohio's law. I just wanted to provide a summary of those so that the list is not exhaustive. And some of you might fall into one or more of these categories. You could be perhaps maybe a school teacher and a pastor. So it's important to keep in mind what hat you're wearing when you're deciding whether or not you have to report an instance of suspected or known child abuse or neglect. The mandatory reporters listed on this slide have a certain set of rules for reporting child abuse and neglect, and there is a special separate set of rules that apply just to clerics, including pastors, and the like. And like I mentioned earlier, I gave you the warning that Ohio has one of the most complicated set of rules for clerics of any law throughout the United States. It's very difficult to understand the intricacies of this law. So again, I think it's great that we're having the presentation to go over the basics of what the law requires. Under Ohio's law, cleric is defined as a member of the clergy or regularly ordained, accredited, or licensed minister of an established and legally cognizable church, denomination, or sect. So if you're an ordained minister or pastor, then you qualify as a cleric under the law. And remember from the past slide, a person other than a cleric rendering spiritual treatment through prayer is a mandatory reporter along with all the other categories of individuals listed on that slide. So the, yes?
Hey, Kimberly, okay, so in a case like this, let's say there's an ordained pastor, but his wife would be doing some counseling. Would she fall under the cleric's rule or under the mandatory?
If the wife is doing spiritual counseling and she's not an ordained minister or another church leader, then she would fall under the mandatory reporter, and she would have a broader reporting obligation than the cleric.
Okay, very good. Thank you.
You're welcome. So what are the rules for clerics, these special, difficult rules to understand? We have a general rule as well as several exceptions and exceptions to exceptions. So fasten your safety belt. It's going to be very complicated, and it's complicated for anybody to understand. So if at any point, just let me know if you have a question, because even the most experienced of attorneys, it takes us a while to wrap our minds around this. So the general rule is listed here on this slide, and a cleric, other than a volunteer, or somebody acting as a church leader, must report known or suspected child abuse or neglect committed by another cleric or other church leader. So to put this a different way, if you, as a minister, learn that another minister or another church leader has committed abuse or neglect, or if you suspect that the other minister or church leader has committed abuse or neglect, then you have an obligation to report under the law. But as I stated, there's an exception to the rule. A cleric does not have a duty to report if the cleric learned about the suspected abuse or neglect in a conversation protected by the cleric penitent privilege. And I'm sure all of you have some level of familiarity with this concept, but as a refresher, in order for a communication to be privileged under the cleric penitent privilege as provided in Ohio law, the communication must be made in confidence, it must be made to the cleric, and it must be made for the purposes of seeking spiritual counsel. So for example, a casual conversation that a minister has with church members or neighbors or friends over lunch, that's not going to be a communication that's protected by the cleric penitent privilege. It must satisfy each of those three requirements. And to make it more complicated, there's an exception to the exception. So a cleric must report even if the communication was learned in the course of the cleric penitent context, if these three requirements are met. A, the penitent is under 18 or under the age of 21 if the penitent is disabled. B, the penitent has suffered or is at risk of suffering abuse or neglect. And C, the abuse does not arise from the penitent's attempt to have an abortion without notifying the penitent's guardians. There's odd reasons for why certain requirements appear in the law. We don't know what prompted the legislature to insert these exceptions and the factors comprising the exceptions, but here they are. So with this exception to the exception we see on this slide, that the real key is to remember who the penitent is. Is the penitent under the age of 18 or 21 if disabled? But even if all of these three, yes?
Is the penitent the aggressor?
The penitent is the person coming to the minister seeking advice, the person making the confession. So throughout the presentation, I use the terms as they are in the law just for consistency, but it can be confusing. The penitent is the person coming to the minister, making the confession, seeking just disclosing any information whatsoever. So the penitent could come to the minister and be the perpetrator of the abuse, but since the penitent is the one seeking advice, that's how they fall under the definition. But the penitent could also be the victim. It's just the person who's coming to the minister. That's a great question. So even if all of these three factors are satisfied for this exception to apply, there's an overriding exception, a sort of stop-off. So the overriding exception states that a cleric has no duty to report at all under these mandatory reporting laws for child abuse if reporting would violate the sacred trust. And sacred trust is defined in Ohio law as a confession or confidential communication made to a cleric if both of the following conditions apply. First, the confession or confidential communication was made directly to the cleric. And second, the confession or confidential communication was made in the manner and context that places the cleric specifically and strictly under a level of confidentiality that is considered inviolate by canon law or church doctrine. So whether or not something is going to violate the sacred trust, that depends a lot on what you get from church doctrine. You're going to need to look to church doctrine, maybe consult with other church leaders to determine if I disclose this, is this going to violate the sacred trust? Courts do not like to get into defining sacred trust any farther than they do in this definition listed on this slide, because if they were going to get into that a little too much, that could be teetering on the edge of violating somebody's right to religion under the First Amendment of the United States. So unfortunately, whether or not the sacred trust exception applies is a little bit up in the air, and it's a gray area, admittedly, under the law. So to summarize all these very complicated rules, to try and boil them down into one slide, the general rule is you have a duty to report suspected or known abuse or neglect by another cleric or church official of a minor or disabled person under the age of 21. And that's if you're wearing your cleric hat. If you're wearing your school teacher hat, you need to report abuse and neglect suspected or known by any other perpetrator. So there's that more limited rule for the clerics, and then the broader rule for all the other mandatory reporters. And again, just looking at the cleric rules, for the second point, the exception applies if the cleric learns of the suspected or known abuse and neglect through a communication protected by the cleric penitent privilege. And that foregoing exception does not apply if the penitent is under the age of 18 or 21 if disabled, and has been or is going to be victimized by another church leader or cleric. And then the overriding exception at the end is you do not have to report suspected abuse or neglect if the disclosure is information that would violate the sacred trust. So whenever you're wearing your cleric hat and you're faced with a question of whether or not you have a duty to report under Ohio law, that final question you're going to need to ask yourself is, would revealing this information violate the sacred trust? That's the final part of your analysis whenever you're wearing your cleric hat and you're faced with this duty to report issue. So once you've determined that you do have a duty to report, what do? You need to report the suspected abuse and neglect immediately by telephone or in person. So you don't want to take a long time milling over whether or not you do have a duty to report or you don't. If you really think that there is a gray area, or if you think you should report, err on the side of caution and go ahead and report. I'm going to get into a little later why it's probably better to err on the side of over-reporting than under-reporting when it comes to the legal aspect, at least. So what do you report when you need to immediately report? Well, actually, where do you report? You report via telephone or in person to the Children's Services Agency or law enforcement officer in the county in which the child resides or in the county where the abuse or neglect occurred. And you report to the State Highway Patrol if the child is an inmate at a state correctional institution. So you're probably not going to encounter that very much, if at all, but there is that special rule. And there's also some basic information that you need to include in your report when you do need to make a mandatory disclosure. And listed on this slide is the information that's required under Ohio law to report. And I know not in all instances you're going to have every item of information, but you need to do the best you can when you're making this report. The information that you should include is the names and addresses of the child and the child's parents or guardian, if you know that information, the child's age and the nature of the child's injuries, abuse, or neglect that is known or suspected to have occurred, including any evidence of previous abuse or neglect, and any other information that you think might be helpful in establishing the cause of the injury or abuse. And under Ohio law, you are, as a mandatory reporter, also allowed to take color photographs of any visible trauma on a child when you become aware of the suspected abuse or neglect. For example, if a child has a very large bruise on their arm, you're able to take a color photograph of that. And if you do take color photographs, then you should submit that along with your report to the Child Services Agency or the law enforcement officer. And one question you might ask yourself is whether the report you make is confidential. That's probably a big concern for anybody who finds themselves in this situation, and it's a very valid concern. So, is anonymity provided or guaranteed to the reporter? So, with several few exceptions, a report made by a mandatory reporter is confidential. Your name and the information you provide in the report is not subject to disclosure for use in a civil proceeding. But there's a couple exceptions to that. It's going to be the running theme throughout this presentation. There's always exceptions. If you violate your mandatory duty to report, other reports of abuse concerning that child can be used against you as evidence. And a report is admissible in a criminal proceeding. The report made against an individual, if they have to face charges in court for criminal charges, they're entitled to have that report produced to them so they can see it as part of their constitutional right. So it is going to be used in a criminal proceeding against the individual, but not against you. If a child who is the subject of a report unfortunately dies after the report is made, but before the child reaches the age of 18, the report is available for review by the Child Fatality Review Board or Director of Health. And a public children's services agency must disclose confidential information if it's requested by a governmental entity, federal, state, local, in the course of that entity's carrying out their duty to protect children from abuse or neglect. So generally speaking, when you make a report as a mandatory reporter, you can feel pretty confident that your name and the information you have in the report isn't going to be disclosed. More often than not, it's going to remain confidential. If you aren't sure if you have a duty to report under a particular circumstance, it's best to err on the side of over-reporting, like I mentioned earlier. And that is because there can be some pretty steep penalties, both civil and criminal, if you violate your duty to report, and nobody wants to face that. So the potential civil and criminal penalties are listed here on this slide. Criminal penalties, it's a misdemeanor in the 4th degree to violate the mandatory reporting statute. So if you're a school teacher and you become aware of suspected abuse or neglect, you don't make that report, you can be convicted of a misdemeanor in the 4th degree. But if you're a cleric and those special rules for clerics apply and you violate that duty to report, you can be convicted of a misdemeanor in the 1st degree. So it gets a little severe. And the person who fails to report is guilty of a misdemeanor in the 1st degree as well if the child is under the direct care or supervision of another person over whom the offender has supervisory control. So sort of the closer you are to the situation and the more you know, the steeper the penalties are if you fail to report. So it's always best to err on the side of caution and over-report rather than under-report and possibly face these criminal and civil penalties. And speaking of civil penalties, a person who violates the mandatory reporting statute can be liable for both compensatory or exemplary, often what we refer to as punitive damages, to the child who would have been subject of the report that was not made. And compensatory damages can be medical bills, psychological bills the child had to incur due to the abuse, and the punitive damages really are, you can use your imagination, they can be extraordinary. They aren't necessarily limited to any reasonable amount. At some point they are limited by the court, but they can be extraordinary expenses. So that's not something you want to face at all, whether you are a mandatory reporter as a cleric or a mandatory reporter as a school teacher. So this has been a lot of information so far. Let's step back and take a look at the big picture here. So you have been discussing your pastoral role earlier today, trying to sort of mesh in your legal obligations with what you might encounter during carrying out your pastoral duties. So what are your legal obligations? To put it succinctly, it is never a legal infraction to report if you do believe there could be abuse or neglect going on. So whereas we saw on the other slide, you could face these really steep penalties if you fail to report, you're never going to get in trouble by the law for making a good faith report if you think abuse and neglect is going on. So that's why it's really important to err on the side of caution if you really aren't sure what to do. You may report at any time you have a good faith belief that abuse or neglect has occurred or might occur, and this is especially true if the abuse or neglect involves a minor or a person under the age of 21 who's disabled. You must report under the very complicated circumstances we discussed earlier. And another important point to keep in mind is your communications with your attorney are privileged communications protected by the attorney-client privilege. So if at any point in time you encounter a question of whether or not you have a legal duty to report, you can go to your attorney and ask your attorney in confidence what your attorney's advice is on the point, and that communication is absolutely confidential. So that's recommended as well. Now I'm going to go through a couple examples to try and show how this might play out in real life. Example 1, a 40-year-old church member confesses to you that he has been abusing his 10-year-old daughter. Must you report? The answer is no, you are not required to report, but again, you may report if you want to. And the reasoning is why you aren't required to report is the perpetrator is not a cleric or other church leader, so there's no mandatory reporting duty. So at all times when we're encountering this question of whether there's a duty to report, you want to think about what hat you're wearing. Am I wearing my cleric hat? Am I wearing my school teacher hat? Or am I just a common citizen who's neither a cleric, a school teacher, or another type of mandatory reporter? So that's the first thing to keep in mind. The second thing to keep in mind is the identity of the alleged perpetrator. Is the perpetrator another cleric or church leader, or is the perpetrator somebody else who doesn't fall under the definition of cleric or church leader? And then you want to think of the supposed victim. Is a victim somebody under the age of 18, or is a victim under the age of 21 and disabled? So those are all important factors to keep in mind when you're doing this analysis in your mind when you encounter suspected abuse and neglect. Yes?
Is this specifically to a church member, or what happens if it's a person outside of a direct person in your own congregation?
So we're looking, example 1, the idea would be that this the cleric is the one receiving the information and a church member is coming to him. If somebody who is not a church member comes to you for the purpose of seeking spiritual counsel, then we would need to look to the cleric penitent privilege and all of that. But if it's just in casual conversation and the suspected abuser does not fall under the definition of cleric, then you don't have your special cleric reporting duties just because the identity of the cleric is just somebody other than a cleric. That's a good question. Yes?
Yeah, but church leader, is that also broadly defined, like a Sunday school teacher?
The church leader, it's more towards ordained ministers and the like, but that would probably be something that would be up to the church's discretion to define. However, the church considers a church leader. If a church considers a youth pastor to be one of their church leaders, then that would fall in the definition. But if the church considers a Bible school teacher, for example, that would probably not fall into the definition of church leader. That is something that's up to the church's discretion. And in the event that a court were to need to review the situation, the court would probably defer quite heavily to how the church defines a church leader.
I have a question.
Yes?
When you say cleric hat or school teacher hat, to me, an ordained minister of God is always ordained. There's never a time when he takes his hat off.
Right. And the law is very gray in that area, but the law is looking at, is the cleric acting in their professional, official capacity? So the law probably wouldn't consider, even though you all probably consider that you act in your official capacity 24/7, and that makes sense. The law probably would not place that burden on you to make yourself acting in your professional and official capacity 24/7. So they're probably looking at during church hours, meeting with church congregants, speaking to your church, doing counseling sessions, something that the layperson who's probably not familiar with the church would think of your official and professional capacity. So although practically speaking you are a minister 24/7, the law isn't going to require, place that burden on you to have these special reporting rules in your non-professional life with your neighbors at a cookout or something like that. And it's a very gray area. It is. Any other questions? All right. So example number 2, a member of the church staff tells you, and you're acting in your professional capacity as a cleric. Each of these examples is based on the premise that you're acting in your capacity as a cleric, unless otherwise stated. So a member of the church staff tells you in a meeting that she witnessed another cleric repeatedly kicking a 12-year-old boy in the basement of the church one day. Must you report? Unless you believe that the church staff member is untruthful, which would be risky, we always want to err on the side of caution, you must report under the circumstance. This is because the suspected abuse was committed by another cleric, and you did not learn of the suspected abuse and neglect through a conversation protected by the cleric penitent privilege. You learned it from a church staff member, just in passing. It wasn't the church staff member seeking spiritual counsel from you, so you would be required to report under this circumstance. Example 3. You are in the grocery store parking lot and you see an adult put out a cigarette on a child's arm. Must you report? This example goes to what you were talking about earlier of when am I wearing my cleric hat, when am I not. So I stated here that you are not required to report, but you may report. So you did not encounter the abuse while serving in your official capacity as a cleric. I made the assumption that if you're off doing groceries, you're not necessarily sitting down counseling church members, you're not wearing your official cleric hat there. And you don't need to report for the additional reason that the abuser is not another cleric or church leader. But again, you may report, you're not required to, but you may. Example 4. A 16-year-old girl tells you in confidence that a church leader has been sexually abusing her. Must you report? Yes, you must report, unless doing so would violate the sacred trust. I remember, as we talked about earlier, that last question you need to ask yourself before you decide whether or not you must report is this disclosure going to violate the sacred trust? So the explanation for this answer is the abuse was committed by another cleric, and the exception to the cleric penitent privilege applies. Remember, we want to look at the identity of the penitent. Here, the penitent, the person coming in for the confession and the spiritual advice, was the victim, and the victim was under the age of 18. Example 5. A cleric who is also a third grade teacher, so wearing two hats at the same time, is teaching a class and notices one of his students has a black eye. The student speaks with the teacher, and the student discloses that his grandfather hit him out of a fit of rage. Must you report? Yes, absolutely, you must report. Here, you learned of the suspected abuse and neglect in your capacity as a school teacher. Although you're also a cleric, at that point in time when you learned of the suspected abuse and neglect, you were performing your school teacher duties, so you were wearing your school teacher hat. And as we talked about earlier, the obligations to report for the mandatory reporters who aren't clerics is much broader than the obligations to report for clerics. So whenever if you're a school teacher, if you ever encounter suspected abuse and neglect, you don't have to go through all those different steps of assessing whether the exceptions apply for the cleric reporting duties. It's pretty easy and cut and dry for the mandatory reporters who aren't wearing their cleric hat. Example 6. A 30-year-old developmentally disabled man comes to you as his pastor and tells you in confidence that another cleric has been sexually abusing him. Must you report? You are not required to, but you may report. And in fact, many states require reporting under these circumstances. And while you may not face legal consequences for failing to report, you should seriously consider reporting or strongly urging the victim to report himself. And I don't want to add another layer of complexity here, but I do want to touch on another mandatory reporting law in Ohio, and that is the law requiring you to report if you know that a felony has been committed. And under Ohio's law, there's an exception for, again, the cleric penitent privilege. So if you learn of the commission of a felony while you are receiving a confidential communication from a penitent, you don't have to report that commission of a felony. But again, err on the side of caution. There's nothing barring you from reporting it. So if you encounter these difficult situations, at the end of the day, it's probably best to report. So the mandatory reporting for commission of a felony that you know was committed, that could be its own day full of discussions with that. But I did just want to touch on that to make you aware that there's separate reporting obligations. And also, yet again, there's another reporting obligation if you find out of suspected elder abuse.
But back again to the earlier comment, so did I understand that if in the course of a confession about something, a different felony is also disclosed, there's no duty to report that. Let's say he robbed a bank. Okay, there's no duty to report that.
Right, if it's learned in the penitent cleric context where the privilege applies, there's no duty to report, but you can. So a couple of different legal issues can pop up during the course of a confession or a confidential communication you have with a church member. So we have the suspected or known child abuse and neglect, the known commission of a felony. It doesn't have to be suspected, it has to be known, and then elder abuse. We didn't get into detail with the reporting of a commission of a felony or the elder abuse reporting, but those are also two reporting obligations that we could spend hours on. So I just wanted to make you aware that those are issues that are lingering out there as well. All right, we went over that. And example 7, you hear that the youth minister went to the movies alone with a 17-year-old church member. Must you report? Sounds very questionable, but you are not required to report, and it's probably not best to report. This is one of those circumstances where erring on the side of over-reporting might not be a very good idea, and that's for a couple of reasons. First, the youth minister is not a cleric or other church leader, but But if your church considers your youth ministers to be church leaders, then you might have a duty to report there. However, going to the movies with somebody without more is not abuse. We always want to look back to that definition of abuse and neglect. Going to the movies with a younger girl, yeah, that might be very questionable, and that might be something that you can impose church discipline on the individual for engaging in, but it doesn't fall under the definition without any more information of abuse or neglect under Ohio law. And given the complicated reporting rules and the harsh consequences for violating them, I've said this several times and I'll reiterate it again, it's always best to err on the side of over-reporting. Even though we saw this minister example going to the movies with a 17-year-old girl, although you might not want to report in that circumstance, it's still going to be better to over-report when you think there might be something fishy going on than to not report and potentially skip over some deeper issues that might be going on there. So having gone through all the definitions and all the legal requirements, there's some suggested protocols you can put into place to help you deal with how you handle instances of suspected abuse and neglect. First of all, it's important to understand that there are those different reporting rules for non-cleric mandatory reportings and cleric mandatory reporters. The broad reporting obligations, again, apply to the non-clerics who are teachers, maybe Bible school teachers, camp counselors, and the like. It's very essential that you develop a written church policy that requires reporting by mandatory reporters and creates guidelines for clerics. Again, we know that these rules are very complicated. There's exceptions and exceptions and exceptions. So it's really critical to have the written policies in place. So when you leave here in a couple months or weeks from now, things start to fade a little bit, that you can refer back to a written policy and refresh your recollection as, okay, what do I do now? What are the best steps to take? And a one-size-fits-all policy is not appropriate. Churches differ in size. Some of you may have a lot of volunteers. Some may have many employees, just a couple employees. So it's really critical to tailor your policy to fit your particular church so it can best help guide the people in your church as to how they should respond to these instances of abuse and neglect. Take every allegation or claim seriously. No matter how many times the person may have cried wolf, it's just going to help you insulate yourself from potential legal liability if you go through the process of reviewing every complaint and taking it seriously. There is no obligation to personally investigate the merits of any specific allegation. The obligation is to report. And in fact, it's advisable not to investigate at all. That might get you into some hot water because, again, your duty to report is to report immediately. And if you spend that time to investigate the allegations, you might be violating your duty to make a very quick report. So it's best to leave it to the professionals, the Child Services Agency, and law enforcement to do the investigation. And again, I know a lot of you are from other states, so if you're from another state, it's important to keep in mind that the reporting obligations are different, and in fact, they're a lot stricter than the reporting obligations in Ohio. In Ohio, a cleric's duty to report is pretty narrow, whereas in other states, the cleric's duty to report is a lot broader, at least the states we've looked at where the meeting participants are from. For example, Pennsylvania, Illinois, Maryland, Missouri, there's limited protection for clergy for certain confidential communications. So there's a pretty broad reporting obligation, and then there's a small exception to your duty to report if you're a cleric. And then in Indiana, there's no special statutory provision for clergy, unlike there is in Ohio. So any individual who has reason to believe that a child is a victim of abuse shall make a report. So in Indiana, it's very cut and dry. If you are a person, no matter what capacity you're acting in, and you find out of suspected abuse or neglect, you have to make a report. So having gone through all of those, thank you for your time today, and I'd be happy to answer any questions you might have, time permitting. I'm not sure where we're at.
Go ahead. I think there are some.
Yes.
Clear back to the beginning on the definition of abuse. I'm just gonna give you an example. I'm from Indiana, so we got the stricter rule, but you hear of a 14-year-old boy taking advantage of a 13-year-old girl. Is that abuse?
So that would be abuse, but would you be required to report under Ohio law as a cleric? No, because a perpetrator is not a cleric or other church leader. But would say the girl is incapacitated and the boy takes advantage of her while she's sleeping, while she's unconscious, if she's disabled and doesn't have the ability to say no, then that definitely would fall under the definition of abuse. And like I mentioned earlier, if there's any question about whether a certain scenario could qualify as abuse, it's good to err on the side of caution and make the report anyways if you think there is any question about it. But if the information is just the two young individuals went to the movies together and they shared a peck on the cheek, that might be subject to discipline by the parents or by the church, but that would probably not fall under the definition of abuse under the law. Yes?
So with Indiana, he would be required if it was true violation, right?
Yes, in Indiana.
From Indiana.
Yes. In Indiana, under Ohio's law, you would have to go through the entire analysis of, am I a cleric, as a perpetrator, a cleric? Did I learn of this through a protected communication? But Indiana, yes, absolutely, there's that very broad reporting obligation. We didn't get into the details of Indiana very much, but generally speaking, yes, if you find out of suspected abuse or neglect, a 14-year-old abusing another 14-year-old, then you do have a duty to report. Yes?
What if it's a minor from another state that moves in, like say from Texas? Do you have to go back to Texas and report that?
No, if the abuse took place in Ohio, then you make the report to the Child Services Agency or the law enforcement agency where the abuse occurred. If you learn of the abuse and neglect here, once the individual moves here, but you find out that it took place in another jurisdiction, I would still recommend that you report to your local law enforcement agency, and they'll be able to guide you through if you need to make a report elsewhere. So always, if you're unsure where to report, go to the local law enforcement agency or child services agency, and they'll be able to guide you through the process. Yes?
We spent time fostering. The year we quit, 3 other pastors quit. You keep saying, always err on the side of caution, but it can destroy. If you don't have hard evidence, it destroys families.
It can. It's a very difficult situation. All you need is reason to suspect, and that's what spurs your legal obligation to go through this mandatory reporting analysis. You don't have to have evidence. Again, you don't have to do your own investigation, and you shouldn't do your own investigation. But once you have reason to suspect, a good faith belief that something happened, that triggers your legal obligation. It can really have some terrible consequences if your reason to suspect turns out to be unfounded, but you don't have to have absolute evidence that it occurred for the law to require you to go through that.
These kids have been, what happened in our county, it's a little different subject,
Mhm.
but the foster kids are older. They're the ones reporting innocent pastors for abuse. And they get put on the front page of the local papers, and it's all folly.
Mhm.
So I watched that side of families being destroyed
Right.
for false information. And so you say err on the side of caution. I don't know, I have a tainted view of that because I'd want, again, I do my own investigation, it'd be too late, right?
Right, and I guess something that can sort of maybe help, not necessarily comfort you in that situation because it's such a tough situation, but as a mandatory reporter, your reports, if you report as a mandatory reporter, you're essentially insulated from liability for making that report. But if those foster children who are not mandatory reporters make a bad faith false report, completely unfounded, they don't do it with any good faith basis, they can be held liable for that. If they're over the age of 18, of course, if they're children, then it's sort of out of your hands. But it's a very difficult situation, and the real life implications of it are tough. They are.
Who would hold those children that make false accusations liable?
So the person who would probably be falsely accused of the crime could hold somebody who is over the age of 18 liable in a civil suit. If the child is under the age of 18, you could try to sue the child through the child's legal guardian. For example, we see instances where a 16-year-old, in a different context, just talking about the general mechanics of suing a minor, if we see a 16-year-old individual drive their car negligently and cause a car accident, you would sue that individual through the child's parent. So the same scenario would probably happen in the false reporting context. If a child made a bad faith allegation, the child knew it was wrong, then you could possibly try and seek recourse through the civil courts by suing the child through that child's parent or legal guardian.
That's where it would become complicated for Mennonite people.
Mm-hmm.
Because
Absolutely.
from a religious standpoint, that is not an option.
Right. And that's difficult because the law enforcement probably would not pursue it. It's tough. And it puts you in a very difficult situation. And the complicated nature of the law does not help any either. So I definitely understand the practical realities of what I'm sure you're facing on a day-to-day basis. And it's admirable that you're able to juggle all your duties and keep both the legal and practical aspects in mind, and hopefully us as attorneys can help guide you through the process when you do encounter a hiccup. Yes?
So, I like to watch the news, follow the different news articles and so on, and in most cases in America, we're supposed to be, someone who's being accused is supposed to be innocent until proven guilty.
Right.
My personal observation is, when there is abuse reported, usually the way it's handled
Mm-hmm.
is opposite of that.
That's very true.
And that comes back to what the other person was saying. If we as plain people don't believe in suing, what recourse do we have?
Right.
We're sort of in between a rock and a hard place.
Right. It's very difficult. And especially the current climate is, even if technically you're supposed to be presumed innocent until proven guilty, the media does otherwise. A complete 180 from what's supposed to be going on. But that's another real reality of the situation. Absolutely. Yes.
I'm trying to think how to phrase this question, but the issue of like let's call it the sacred trust.
Yes.
You know, where if I understand this correctly, if the church has like canon law
Mm-hmm.
or church doctrine that speaks to this matter,
Mm-hmm.
okay, then that creates the sacred trust that
Yes.
provides almost like this cocoon, if you will, or this safe space.
Yes.
Okay? Well, so in the Mennonite church, we, unlike, let's say, for example, Catholic Church, the Lutheran Church, or other Protestant denominations that are highly organized and have established canon law or
Mhm.
church doctrine. We're this very loosely organized potpourri of all kinds of Mennonites. And like this room full is together because it's on a kind of like on a fellowship basis.
Right.
Not on a constitutional
Mhm.
basis where we agree. So we actually almost like don't have this sacred trust.
Mhm.
Like from a legal perspective, do Mennonites have the sacred trust or do we not?
Right, we would have to look to the individual church doctrines, and if you don't have an individual church doctrine that would speak to this, then the law probably is going to say that there's no sacred trust here. Even though the courts don't dabble too much into it, if you would have to get up on the stand and testify under oath, the court would say, okay, point to me where in the church doctrine or church canon law where you would have to keep this strictly confidential. If you say, honestly, Your Honor, we don't necessarily have anything concrete in that respect, then that could get you into some trouble. So if there's no church doctrine that speaks to it, then that last final question of whether this violates the sacred trust might not be something you need to encounter a law, and you might have a broader reporting obligation. Yes?
So this is a 2-point question. If I'm not mistaken from different research I've done in the past, it's very critical it's written. Is that right?
It was what?
It's written down. It needs to be written.
It's definitely helpful. It would be abundantly helpful in the event that you would have to defend your decision to file it under the sacred trust. But again, courts aren't going to dabble too much into it. The definition I provided to you of sacred trust is pretty much all that the Ohio law has to say with respect to this statute. So does it need to be written down necessarily? Probably not for the purposes of Ohio's reporting law. Is it helpful? Definitely.
How can you defend it if it's not written?
The court assesses credibility. It would just be a credibility determination. For example, if one church member, excuse me, if one church member were to say that this is something in our church doctrine, and another church member or 500 other church members were to say, no, actually, that's not our church doctrine, then the court would weigh the credibility of the witnesses.
So, according to the question that was raised earlier, if there is not sacred trust, in the plain Mennonite churches and so on, some churches function that there's 50 churches and they all function according to the same doctrine. And others function more as each individual church. So how we would, as churches, be able to establish a sacred trust, right?
Sure, absolutely.
So how would we do that? How do you decide to what level that is established?
That would probably more be up to the determination of the church leaders. That the court isn't going to impose a requirement of the church has to consist of X congregants in order for you to have your own sacred trust. That would be up for you to decide under your First Amendment rights of free practice of religion.